Hello everyone, I'm going to deliver another law lecture now, and this one is going to be about precedent, which is a core doctrine of English law. So hopefully by the end of this talk you should know various things. You should be able to elucidate what this doctrine is of a binding precedent. You should be able to tell apart binding and persuasive precedents. You should also comprehend just how crucial court hierarchy is in relation to precedent, and you should understand how the ratio of a decision can be found. Ratio decidendi, there are various different ways to pronounce it, it's Latin anyway. And you should be able to grasp the distinction between overruling, reversing and distinguishing cases. There's a very good book on this called Learning Legal Rules. So first thing is to know about stare decisis. I know some various people pronounce it different ways. We don't know how it's pronounced anyway because it's Latin. So as in stand by the decision. So this is a distinctive feature of English law, but you find it obviously in other common law systems. My point is it's not a big thing in Roman law. So that means there's binding precedent in English law. What is this? The core of it is there's that once a principle has been explained by a court, similar cases in future with a similar factual basis must be decided in the same way. So that's quite different to Roman law systems where they have written codes of law and they're not interpreting previous decisions so much. The decisions cited are simply examples of how to apply the code. Remember, a Spanish lawyer said to me, you've got the law, you've got the facts, and in theory you should be able to create a computer which just applies the two together and reaches a decision. Well, English law is decidedly different because, of course, Spain's legal system is a Roman law one. Anyway, so if a court has to follow what was decided in a previous case, the court first of all has to determine what a part of that case is binding, and second of all, which a court decided this. In the previous case, was it a superior court, an inferior court, or one of the same tier? Tier is the level in the hierarchy. It's T-I-E-R, not tier as in lacrimating. So which bit of the decision is the binding one? So once a point of law has been decided by a higher court, that it sets the precedent, and the precedent could be binding, in which case the lower court is obliged to adhere to it, or it could simply be persuasive. So it's not binding, but that's quite convincing. You might choose to go along with it, or you might decide that you wouldn't. You should have a fairly good reason not to. So not every a statement in a judgment is binding. So a judgment will consist of some précis of the relevant facts, and then there'll be statements of law, and there'll be the ratio decidendi, or reason for deciding. There'll be some obiter dicta, which are other statements made in that judgment, but they don't form part of the ratio decidendi. So the decision which is made between parties is only binding on the parties, not on the court. Remember that. So ratio decidendi is the binding part of a judgment, and it can set a precedent. So ratio for short, pluribus rationes, and the court says we reach a decision and this is why. So it'll be elucidating the law and applying it to the relevant facts. So then there's the obiter dictum things, which are said to be said by the way. Okay, so this is also germane, but it's not as critical as the ratio decidendi. So the judge will make some remarks on this aspect of law, but it's not essential for courts in future to reach a decision in the same manner as he or she has done. So obiter dictum is the singular, obiter dicta is the plural. So these statements are not binding on other courts, although courts will often say, I'm persuaded by that. They quite often go along with that. So the court will say what the law is, and even if this is not essential to the decision reached, and it might speculate on fictive cases, like supposing such and such were to happen later on, Well, what would we do? I think this is what we do. There'd be hypothesizing. So there will be other statements made about law as the judge would like it to be, but said, well, I can't do because there's precedent. Now, there might be a dissenting judgment if there are several judges on the bench. And so we would also listen to what the minority said, and indeed that minority in time might become the majority. The minority viewpoint later on might be agreed with by others. Like, for example, say in the early 70s, when the United States Supreme Court decided that the death penalty was a cruel and unusual punishment, so it was unconstitutional, but a minority dissented. Now, about 10 years later, that changed, and the minority became the majority, and the majority of justices on the US Supreme Court said, it's not cruel and unusual, the death penalty is permitted once again. So obiter dicta comments can be vital, even though they're not the part which actually led to the decision being made. So there's Ungode Thomas, who was a judge, and in Ray Grosvenor Hotel, London number 2, this is a 1964 case, he said, a battery of howitzers off target is more impressive than a pop-up gun on it, as in on target. Powerful obiter dicta by the House of Lords may sometimes be regarded as persuasive, so persuasive as to be practically binding. So let's look at the decision now. Now this is the decision that was made between parties and is binding only on them, not on others. Now it could be changed if there's an appeal, but it won't be affected by decisions in previous similar cases. So let's come on to the material facts, or the relevant facts, as I quite often say. So the report of a case will contain innumerable facts, but not all of them will be material to the decision that was made. So let's look at the ones which are germane to this. Say, well, there was a man and he had red hair. Yes, but that's not why we found him not guilty of kidnapping. So the red hair is not relevant. So when applying law to a set of facts, we need to be able to realize which ones are crucial to the decision making. Material facts, as we say, others are immaterial. So we'll look at ratios in other cases. You could be following them, approving them, or applying them. So when a court turns its mind to the facts of a case, which are similar to another earlier case, the court sees how the law was applied in the earlier case. So they could be following the decision of the earlier courts. So the courts which do the following could be a higher court. So that later decision is said to be approving the decision made by a lower court. So where a court in a subsequent case contemplates the facts of a previous case, which is quite akin to the case before the court in this particular case, in this particular situation, and therefore it applies the law. As in the previous case, the court is said to be applying the earlier decision. They're related but different. If that sounds complex, well, it is. Now then there's reversing, overruling, not following, disapproving, which again are all related but a little different. So it's vital that you grasp the distinction between a judgment being reversed, and that happens only in a single case, as it goes through various appeals, and the court's overruling or departing from precedent. Okay, so Joe Bloggs is found guilty of murder. The Crown Court goes to the Court of Appeal, and he's found not guilty. Okay, he's free. So they reverse the earlier decision, but they haven't overruled the court saying, we think the murder is okay now, or something like that. So a judgment is reversed if a case is appealed and the higher court thinks that the lower court got it wrong, erred in law, for example, and that's not undoing precedent. But a precedent can be overruled if the higher court in a subsequent case decides that the earlier precedent was mistaken, and therefore a new correct precedent must be introduced. The original precedent is no longer valid. For instance, the Supreme Court can overrule a previous precedent from the Court of Appeal. But we would say if the Supreme Court departs from precedent, if it's going against its own precedent, and therefore the law has been changed that way. Now, there's another way of dealing with this. A later court may decide not to follow or to disapprove of a law in an earlier case without overruling it. Incidentally, not follow or disapproved are regarded as synonyms here. And so that may weaken the authority of the earlier precedent, and it may have an impact on the way it's interpreted in future cases. So if a judgment is reversed or a precedent is overruled, or even partly overruled, some parts of it, of the early decision, may still be there. They may say, this part of the decision was wrong, but the rest of it is right. That remains intact. Now, a case in point would be Lloyds Bank plc and Rossett, 1991. Okay, this is a case in land law that you're hearing a lot about. So this was the home of a married couple. It was in the husband's sole name, and he mortgaged it out to the bank. So the bank sought to repossess it, and Mr. Rossett's spouse, she refused. So how could she succeed against the bank? Well, she had to demonstrate two things. Firstly, that she had a beneficial interest in the property under an implied trust, and secondly, her actual occupation is what protected it, because she was there superintending builders who were renovating it. So in the Court of Appeal, the wife, Mrs. Rossett, she won a case. So the court says, actually, she does have a beneficial interest, and her physical occupation of the premises proved that. So the House of Lords threw out the decision because they said there was no beneficial interest there in the first instance. Now, the actual occupation, that's the legal phrase, they didn't concern themselves with that. Okay, so actual occupation, the definition of that was unchanged, but the claim that she had a beneficial interest, that bit was rejected. Anyway, if they'd expressed any viewpoint on actual occupation, that would have been obiter dicta and not ratio decidendi, because the actual occupation was not germane to the decision reached by their lordships. Anyway, the decision of the Court of Appeal regarding actual occupation still remains good law. Now we come on to distinguishing. So a court might wish to obviate the need to create a precedent if it can distinguish an earlier case, saying, no, these are materially different. Not only are they different cases, but they're significantly different. They're not really comparable. So this shows there's some flexibility. Now, this might appear to be false and convoluted to people, but anyway, come on, they're lawyers. What would you expect? So they might say an earlier decision can be relied upon, but it's not similar to this decision before the court right now. Therefore, we're not overturning any precedent. So now we have to be able to pick out the ratio. We call it that for short, ratio decidendi. The ratio might not be easily apparent if you read the judgment of the case, and that's because the judges might state numerous reasons for their decision, and the reasons might not be lucid to you. And there could be several judges on the bench, and each one of them may give a different reason, and they often have agreed in it. It's called res judicata. Or sometimes they just say, I've got nothing to add. It also might be a question of emphases. This justice, she says, X is the most important reason, but Y is also reason, whereas this judge, he says, no, Y is more important than X. Anyway, there is another thorny issue here. You have to look at how broad the ratio is supposed to be and how broadly applicable it is in future. The ratio could seem to be a very restricted proposition of law, or a rather broad one. So if it was a very narrow one, it would only apply to cases which had great verisimilitude to the case before the court in that particular instance. If it was one with a very broad applicability, then it could be applied to a whole category of cases, and it might be even creating a new area of law. So judges in a case may say how broad they think the ratio ought to be. So judges in cases later on might say, well, I have to follow that ratio because it's very broadly applicable. And now if they disagree with the decision, they could say, no, this ratio is actually quite restricted and it's not applicable to the case before me right now. So this is known as confining the earlier case to the facts, as saying, well, that case is rather different from the one I'm facing now, so that principle just doesn't apply here. Anyway, so for instance, there's the celebrated case of Carlyle and Carbolic Smoke Ball, 1893, one of the first leading cases in contract law that you'll learn. So the defendant had made this cure for flu called Carbolic Smoke Ball. The ad put in the paper said they pay £100 to anyone who caught flu after using it, provided they follow the instructions. And £100 was a huge sum at the time. So Mrs. Carlyle, she read the ad and she used the remedy and she followed the instructions to the letter. But despite that, she still caught influenza, so she wanted to claim the £100 reward. Anyway, the defendant argued that the advertisement was a sales puff, a mere puff. I would say, "Oh, suits you, sir, lovely suit on you," equivalent of that. That's not a statement of fact. You can't sue someone and say, "Well, I bought it because the salesman said it looked good on me, but actually it doesn't look good on me." Well, no, you'd have no case in law there. But the Court of Appeal said this is not a mere puff. This is purporting to be a factual claim. So the defendant had to pay the claimant. Mrs. Carlyle got the reward. So the most constricted understanding of this ratio would say would only apply to selling flu medicine. But if that were true, then it wouldn't be applicable to those who sold treatment for acne or something. There didn't seem to be any logical reason to say this doesn't apply to medication in general, or maybe any product. So anyway, is it only about advertisements for things to keep you from catching flu? Now, a broader interpretation of say, well, this rule is applicable to all advertisements. Some people say, well, that's just not accurate. Other courts have taken the ratio from Carlyle and carbolic smoke pool and say they've applied it to cases which didn't even have advertisements as part of them. So what's the doctrine we've established here? Well, the courts say that the principle at stake is a thing called unilateral contract, which is binding upon the offerer once another person accepts the offer and they fully adhere to the conditions of it. So that's the way the court worked, a broad interpretation. Now, some people say the best way to find out ratio is to look at a law report. The law report will usually have a text including the judgment, there'll be a head note, and there'll be the vital information, and it will have a bit in it where the law reporter, who's usually a barrister, solicitor, who does this kind of thing, explains why the bench took that view. And we often say held, write the word held right before we actually come to the judgment. So what are the prerequisites of precedent? So for the system to function, we have two prerequisites. First of all, a efficient system of law reporting. That's why there are solicitors and barristers who know what they're doing when they write these summaries of cases. And second of all, there has to be a clear hierarchy of courts with tiers so we know whose decisions are binding upon whom. The law reports are published, and they're often specialised ones. There's Lloyd's reports, which is about insurance because of Lloyd's of London. There's the family law reports. There are the weekly law reports, the All England law reports, and on about Chancery Division, Queen's Bench, Western law reports, appeal cases, family division, and on and on. They were started in 1865. Nowadays they're actually signed off on by the court, so it's got the imprimatur, so we know they're getting it right. There are things like LexisNexis as a network of the law, which is to pay to have access to. And you can get reports from the United States, from the Commonwealth and the European Union. So there's an endless amount to read. You know how to look it up. Okay, so the courts, the reports will have some of the pertinent facts of the case, and then they'll have the decision and, crucially, the reason for reaching that decision. So they don't report every case. Some are completely unexceptional, unsurprising, following precedent. There's nothing new. If there's some sort of movement, there's something we need to know about. Okay, so they will also see the arguments of both sides in the case. Anyway, Times law reports as well. The Daily Telegraph used to publish brief law reports. So only about a tenth of cases from senior courts are reported. Magistrates' court would almost never make it into a law report. Ordinary newspaper might report if it was a juicy murder or something, but there's not really going to be a point of law established at that level. And that's a sort of a first instance hearing before saying, well, yes, you're remanded in custody, trial will be in the Crown Court. Anyway, so what are the pros and cons of the current system of precedent? Well, we supposedly have a certainty, although I'll come back to that. It should be a little bit predictable. It's a more practical. It also adapts to a changing world, and law is forever evolving. Anyway, what are the downsides of the current system? Perhaps it's ossified. Could it be it sacrifices the broader issues for the sake of doing justice in the individual case? Maybe it's unpredictable. It seems to contradict the earlier claim that it was predictable. Anyway, there are just so many cases which can't be properly have precedent applied to them, or perhaps the law is too slow and doesn't keep pace with the social reality. In Spain, that's one of their laws, that the court has to reflect social reality. So, and then there's this vexed question: do judges make law or not? And if they do, should they? So people said, oh, they don't say what it is; they merely interpret it. This is connected to the retrospective character of precedent. The viewers of decisions are based on statements of what the law actually is, and they've always existed, but they just didn't have a chance to articulate it. However, there are others who say no, statutes say what the law is, and the judges are just interpreting it, and judges don't want to upset precedents that have existed for a long time, especially in things like criminal law. Anyway, so that is just a very brief introduction into precedent. Toodaloo.